Any mention?
Your Lordship, I beg to mention item number 11. This matter come out after 2 weeks, Your Lordship.
11, 12, 13 and 14, Your Lordship, these are connected matters.
These are all matters.
Yes.
School matter.
Yes.
Lordship,
Department
yes.
of Teachers.
Appointment.
Yes.
No. Is it dismissal or for?
No, Your Lordship, this is appointment.
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 Our case is that unqualified persons have been appointed.
You are for petitioners.
Yes.
In item 12.
11, 13 and 14, Your Lordship.
Why are we? What is your ground?
The conducting counsel is having some part heard matter, Your Lordship, in courtroom number 2.
That is usually not an excuse. Personal difficulty,
Yes.
maybe. Huh? You break your leg, you break your hand, maybe. But you can still speak.
Since they have difficulty, Your Lordship.
All matters you cannot just go on adjourning one date to another date, one date to another date. How long?
Yes, Your Lordship.
How long?
2 weeks, Your Lordship.
Ensure that next time no more.
Come on, 19 then, Your Lordship. 19.
19.
Lordship, yes.
Fine.
Fine, Your Lordship.
On pre-made by the parties, let's this matter after on 19.
Lordship, the petitioner is praying, the state is not praying for adjournment, Your Lordship.
Pre-made by the petitioner. So 12
12,
Yeah.
12
Connected
13,
with-
14, Your
they are
Lordship.
connected.
corrected.
On the same issue, Your Lordship, the same issue.
So Mr. Siddiqui, you are there in 12,
Yes,
13
12,
and
yes.
This matter can come
13,
on
14?
19, Your Lordship.
I am for 12 months.
12. And who's for 13 and 14?
Yes.
Me, Your Lordship.
No,
On 19, Your Lordship.
19.
Lordship, highly obliged, Lord.
Wait, please, Your Lordship. Your Lordship, I beg to mention item number 7. Your Lordship, the conducting counsel, Mrs. N.G. Shilla, is on a medical leave, Your Lordship.
Your Lordship, we were required to file a show cause. On the last occasion, an impleadment application was filed.
Impleadment?
Lordship, yes, there's an impleadment matter was already in the hearing column for a long period of time. On the last occasion, Lordship, an impleadment has been filed by the applicant concerned. So I was to file a show cause to that.
What is this case about?
It's regarding regularization of a teacher, Lordship. Now, impleadment application has been filed saying that he is occupying that post now. So I have to file a show cause to that, Lordship.
But you are not functioning.
My instructions is that I am service even till today I have gone to school, Lordship. So that is why I am to file the show cause to that application, Lordship.
Okay. School matter?
School matter, because he has relied on certain documents which are not found in any of the affidavits which have been filed in the matter. So I don't know how those documents have come, Lordship.
Who has filed that petition?
Lordship, it was some counsel. My friend
You have filed. You have served them with copies.
Yes, yes, Lordship.
We'll adjourn the matter and in meantime you file your response.
Order is already there.
Okay.
You take it after 2 weeks.
On pre-made by Ms. Lenergy. Seeking accommodation, that is adjourned. This is after 2 weeks.
Obliged, Your Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 10. Your Lordship. Your Lordship, praying this matter may come up after 2 weeks, Your Lordship.
Two weeks.
Anyway.
Lord, I beg to make a mention of item 8, my lord. Lord, I am the new counsel. I am yet to file my powers, my lord. This matter is kindly listed after 2 weeks.
Your new counsel?
Yes, my lord.
On permit by Mr. K.P. Parchari, learned counsel, was submitted that he has just been recently engaged to take up this matter on behalf of the petitioner. As such, some time is sought for to file his power and to matter is on prayer. Accordingly, matter is adjourned. This is another 2 weeks.
Obliged, my lord.
Please, Your Lordship. Your Lordship, I beg to mention item number 16. Your Lordship, I'm praying that this matter may come up after 2 weeks.
It may be last chance, Your Lordship.
What is this matter? This against discharge
Against acquittal, Your
Acquittal,
Lordship.
Your Lordship.
Yes.
or criminal appeal?
Yes, Your Lordship.
Have you filed your paperwork? Everything is ready.
Your Lordship, we have not been directed to file a paper book, Your Lordship.
But usually in an appeal,
It is in admission stage, Your Lordship.
but this admission stage
Yes, Your Lordship.
must have been
They
there.
file a petition for leave.
Oh, leave.
Yes, Your Lordship. So we have also filed our objection here.
Okay, only for hearing on that.
Yes, Your Lordship.
Well, should be admission hearing then.
Yes, Your Lordship.
So this is in 16 or 17?
Sixteen.
16, Your Lordship.
16.
16, Your Lordship.
In the trial court, the CBI is a prosecuting agency.
Yes, Your Lordship.
Then why leave is required?
Because they have filed appeal against acquittal, Your Lordship. So it's mandated under 419 BNSS.
That is, see, that is a matter of formality. Nothing, you see, nothing to be opposed. If it is,
We have the liberty to file, Your
if it is
Lordship.
a statutory right, then
It's a statutory right, Your Lordship. It's under 419 BNSS.
419, 418 or 419.
Yes, Your Lordship.
So, why would we delay, delay hearing of the appeal as such? Okay, we'll take it up after 1 week. 1 week.
Lordship.
Sixteen, 17.
No, Your Lordship,
no,
only
16.
16.
See, premeditated by. This is matter of 1 week.
Deputy.
Lordship, I beg to mention item number 17, Lordship. Criminal appeal, my lord. I need some more time to prepare, Lordship.
Matter has been heard.
No, my lord. It's not been hard.
So why would you prepare? He has to prepare. He is to start. Because I know that you will ask for next date to answer, to reply.
No, my lord. I needed some time to. I don't want the POXO matter, my lord.
You just have to sit there and listen to him.
And it's in the bottom of the list, my lord. So there are other matters. So we thought.
You don't want to be. You don't want to sit here the whole day.
No, my lord. Another 2 weeks time, my lord.
Yes, on premeditated by this is matter to 2 weeks. 2 weeks then.
2 weeks.
May I please, Your Lordship? I beg to mention item number 9, Your Lordship.
Item number 9.
Yes, Your Lordship.
You are for?
Your respondent number 2, Your Lordship.
Who's for petitioner?
I'm here, Your Lordship.
So,
This case has been heard already.
just a minute. Oh. This matter has been heard.
Yes, Your Lordship.
Then what is required?
Your
For the
Lordship.
last 6 months, they are supposed to file this written argument. They are not filing, my lord.
You are claimant.
No, Your Lordship.
You are claimant. And you, who are
I'm
you?
the owner, Your Lordship.
Driver, owner of the bike.
You were there in the before the MSCT.
Yes, Your Lordship.
You had filed your WS.
No, Your Lordship, till now.
In the trial court.
Oh, in the trial court. Yes, Your Lordship.
Have you filed your written argument?
Not yet, Your Lordship.
Matter has been heard. Hmm?
Yes, Your Lordship.
Only for filing of written argument
Yes,
by
Your
all
Lordship.
parties.
I have filed my written argument.
Okay. Do it. Just filing of written argument. How long will it take?
Your Honor, in the, it should be given short date, Your Lordship. On Friday, we'll submit our written argument.
You filed it.
Okay, Lordship.
Made by parties. This is matter of 2 weeks.
Much appreciated, Your Lordship.
Made by you, the owner, respondent owner.
Supplementary list, item number 1.
File the paper book.
Lordship, 1 week may be given, Lordship. It's almost ready, Your Lordship.
Miss Letter Counsel for the appellant has sought for some more time to prepare the paperwork. Pray aloud. This is matter of 3 weeks.
Lordship. Item number 3.
May I please, Your Lordship? Your Lordship,
I am for the petitioner.
Yes, please.
The state has filed a small affidavit yesterday, placing on record the notice published by it, directing that now it is the UGC who is the ultimate authority. But my lord, I would like to find a response to that, because in the garb of issuing that public notice, what they are trying to do is they're trying to, my lord, and when they do that, my lord, they just simply pass an order directing us to refund the fee. So what they can't do directly, my lord, they have been doing it indirectly now. So please allow me a week's time, my lord, to file a response to this application or an independent application and take up this matter, my lord, at the yes.
Mr. Singh, here, firstly, we are concerned with this corrigendum.
Yes, my lord.
So, this corrigendum has been brought on record, Mr.
Yes, my lord. Corrigendum is, my lord, issued. Yes, my lord. That was filed yesterday.
Okay. So, you want to file a response to that?
Yes, my lord.
Fine.
Your Lordship,
Only bringing on record, my lord, the
corrigendum
conduct of
is in
one of the
compliance with
respondents.
Supreme Court's order in the review petition, Your Lordship. This corrigendum is in compliance with the Supreme Court's
Whatever.
order.
He wants to file a response.
Sure.
If it is beyond the scope of the Supreme Court's order, then he has a right to refute whatever you have stated. So, 2 weeks time, Mr. Singh?
I am so grateful, my lord. Have it on 16th, my lord, if possible. But I have got another hearing, and that is the reason why I am saying, my lord.
16.
Would not have 16th as well. I am so grateful, my lord.
Mr. Leonard Counsel for the respondent has submitted that the affidavit bringing on record the corrigendum as directed by this court by order dated 16/2/2026 has been filed. In reply, Mr. A.P. Singh, Leonard Counsel for the petitioner, has sought for time to respond to the same. Pray aloud. As prayed for, this matter on 16.
I'm so grateful.
Item number 4.
Much obliged.
For the written argument, my lord, I'm praying another 1 day time, my lord. I'll file by day of tomorrow is holiday, day after tomorrow, my lord.
Next week, my lord.
Ms. has sought for 1 day's time to file the written argument. Accordingly, as prayed for, list this matter on 6th.
Item number 5.
Yes, who's appearing?
Mr. EG is.
EG?
Yes, ma'am.
But he's not here. End of the vote?
Ma'am.
What do you say?
As per your lordship.
We'll wait till end of the vote and see.
Yes, ma'am.
Item number 15.
This matter has been heard? Not.
What?
Has this matter been heard?
No, no. Well, this is on a very limited point. The award of the passed by the tribunal has been challenged only on a limited point that whether the deceased who was driving the vehicle of his wife is the registered owner and husband was driving the vehicle, whether he can be treated as a third party. Because it is a settled position of law, my lord. There are cases of Supreme Court also which is now husband has stepped into the shoes of the he stepped into the shoe of the original owner. So husband who was driving, though he is possessing a driving license, that is not under challenge whether he was qualified to drive or not. But he was driving with the permission of the registered owner. When the husband was driving, for that matter, any family member who was driving the vehicle of the registered owner, he stepped into the shoes of the registered owner. So once he steps into the shoe of the registered owner, he becomes the owner driver. And the insurance policy had the PA cover. So he will be entitled for compensation only PA cover for owner driver. That whatever. The 2 lakhs as per that this particular policy is covering owner driver for 2 lakhs. That policy has also paid an extra premium of 50 rupees for other occupants of the vehicle. Now the tribunal below has given the compensation considering him as a third party, which is not permissible under law. And that any other occupant of the vehicle which is covered by paying that 50 rupees extra premium, that would be, even if it is applicable, that would be for other present, not for the owner driver, because he steps into the shoe of the registered owner, and once you step into the shoe of the registered owner, he will be treated as driver owner and cover under PA cover. That is the only point which needs to be decided.
So now the issue would be whether the deceased, he is the deceased, he was the deceased.
He is the deceased.
Whether the deceased could be husband, whatever relation.
This is an admitted fact. This was the husband of the registered owner of the vehicle.
By virtue of him being husband, so he is considered to be also the registered owner.
Registered owner. He steps into the shoe of the registered owner, and as such, once he steps into the shoe of the registered owner, he is treated as the owner, an owner plus driver way. There is no, we are not into whether a petition was maintainable under 163A or under 166. All those we are not
except on that
challenging.
point.
And even his driving license, that own driver deceased, his driving license, those are also not under challenge. So we need not go into all those evidence, all that part. But the fact here is, okay, accident is admitted, insurance policy coverage is admitted, and that he died in the accident, okay, those are also accepted. Now he was having a proper driving license. The only fact, the insurance policy had paid the PA cover of 100 rupees. It also paid other occupants cover of 50 rupees extra. So in such a policy, if PA cover of 100 rupees extra is paid, that is for personal accident of the registered owner driver. And that limit is fixed in the policy. It is in case of permanent injury, 50,000 or 1 lakh, and death is 2 lakhs. Now, the deceased for whom the wife as the legal heir has filed a claim petition will be treated as stepping into the shoe of the registered owner because he was driving the vehicle. He is not a paid salaried driver. Had it been a salaried driver, then also driver cover, that will be a different matter. But he will not be treated as a third party because he, with the permission of with the knowledge and permission of the registered owner, he has driven, and being a family member, he was driving the vehicle, he stepped into the shoe of the registered owner, and so he will be covered only under PA coverage of 2 lakhs, and that's it. But the trial court has awarded taking him, considering him as a third party, because this is an important question of law. It will affect other cases also. It will become a precedent for subsequent cases. That is why the insurance company is before you.
You have authorities in that regard?
We have the case given. No? This is reported. This is Ningamba and another versus United India Insurance, reported in AIR 2000. Which citation you have given? 2009 Supreme Court 3056. In this case also, here the relative was driving. There has been in paragraph 19 yes, relevant portion.
Just a moment. Paragraph 19.
But I don't know whether that will be because mine is not from the book. Paragraph 19 here it is saying we have already extracted section 163A of the Motor Vehicles Act.
Just a moment.
Where is that a case? Relevant portion.
Yes, this is paragraph 19.
Where perusal of the said provision would make it explicitly clear that the persons like the deceased in the present case would step into the shoe of the owner of the vehicle in a case wherein the victim died or where he was permanently disabled due to an accident arising out of the aforesaid motor vehicle. In that event, the liability to make payment of the compensation is on the insurance company or the owner, as the case may be, as provided under 163. But if it is proved that the driver is the owner of the motor vehicle, in that case, the owner could not himself be a recipient of compensation, as the liability to pay the same is on him. The proposition is absolutely clear on a reading of 163A. Accordingly, the legal representative of the deceased who have stepped into the shoe of the owner of the motor vehicle could not have claimed compensation under 163A of the Motor Vehicles Act. That is not a third party. And the other one? There's another case where it is more Kuraisa Bibi versus Pushpa Devi Gupta. In this case, it is more given this one. In para 11, my lord.
What is the journal for this?
This is from High Court of Jharkhand, Ranchi. Para 11, my lord. The insurance policy is available on record.
This is reported in which?
This is not reported.
Not reported, Your Lordship.
Not reported. The insurance policy is available on record, wherein.
Just over here. You're citing para
11.
11.
Insurance policy is available on record, wherein PA cover under section 3 for owner driver is said to be 2 lakhs, meaning thereby that insurance is there. It is not clear from that if only the owner is driving the vehicle, then only that clause will apply. It is in the form of owner driver, meaning thereby whoever is driving the vehicle is entitled for, and PA cover is there of rupees 2 lakhs. And if such a situation is there, certainly deceased entered into the shoe of the owner, as has been held by the Honorable Supreme Court in the case of Ram Khilari and another versus United India Insurance Company and another, wherein the Honorable Supreme Court in para 98 has held. However, at the same time, even as per contract of insurance, in case of personal accident of the owner driver is entitled to a sum of rupees 1 lakh. Therefore, the deceased, as observed herein above, who would be in the shoe of the owner shall be entitled to a sum of rupees 1 lakh, even as the contract of insurance. However, it is the case on behalf of the original claimant that there is an amendment to second schedule and a fixed amount of 5 lakhs has been specified in the case of death, and therefore the claimant shall be entitled to 5 lakhs. The same cannot be accepted in the present case here because their 5 lakh amendment was there to enhance to 5 lakhs, but in this case Supreme Court said your policy was issued prior to the amendment, so it will be which is limited by the agreement.
So same case here.
Here it is 2 lakhs as per the.
No, but what about this amendment?
Pardon, my lord?
This amendment?
No, this will not affect our case, my lord.
Okay.
But prior to the amendment in second schedule. In fact, the circumstances of the present case, the claimant shall not be entitled to the benefit of the amendment to the second schedule at the same time as observed hereinby. The claimant shall be entitled to the rupees 1 lakh as per the terms of contract of the insurance, the driver being in the shoe of the owner of the vehicle. In view of the above judgment, the appellants are entitled for a sum of rupees 2 lakhs with statutory interest at 7.5% per annum from the date of application. As such, the insurance company is directed to pay 2 lakhs along with the interest at this rate. So here also it is the owner, whoever driving, would if he is not a salaried otherwise driver, not an employee.
Yes.
See this case? This is the example. This is already read out. See, this Ramkilari case, that is the extract which I read out from here. So in this case, if your lordship will see the insurance policy, the findings of the trial code below. At page 19 of the paper book, my lord.
Page 19.
19.
Yes. Yes.
The tribunal treated the husband as the third party.
You are reading which paragraph?
My lord, just 1 minute. Para 64, my lord. There the findings of the tribunal. This tribunal, in view of the term laid down in Exhibit 9. Exhibit 9 is the para 64 at page 21, my lord.
Okay.
This tribunal, in view of the term laid down in Exhibit 9 and applying the principle laid down in Master Suraj Subha, found that insurance policy in the instant case is a package policy and the deceased husband of the claimant cannot be said to step into the shoe of the claimant, but is said to be a third party in the instant case. The deceased husband of the claimant is also said to hold a valid and effective driving license at the time of the accident. This tribunal thus found that there is no breach of the terms and conditions of insurance policy and the insurance company is liable to pay any compensation. By relying on a case law of Honorable High Court of Sikkim, where they have taken the husband as a third party. But that is the only question now. That was also national insurance was there. Sikkim High Court has treated the husband as a third party, and on relying only on that decision, only tribunal has held it. So that needs to be adjudicated by your lordship independently, irrespective of whatever is the finding of the Sikkim High Court, whether a driver husband or a family member possessing a valid driving license that is not disputed or that is not under challenge, who is driving the vehicle with the not as a paid driver, not as an employee, but with the consent and knowledge and consent and permission of the registered owner. He steps into the shoe of the registered owner and whether he can be treated as a third party. That is the only issue in this case, my lord. I agree that the tribunal has held it relying only on that Subhas case passed by Honorable High Court of Sikkim. Relying on that case, tribunal has passed it. It is only on that. We are not on that case, not insurance company do not want to absolve itself from not paying, but whether it will be treated as a third party, if it is he cannot be treated as a third party, because this will create a precedent for his future cases also. Now, if he steps into the shoe of the owner, he will be entitled, and the PA cover is there. The insurance policy which has been enclosed here, the insurance policy clearly shows that PA cover is there, and which will be only for insurance policies in insurance policy, page number 1. Where's the insurance policy? Yeah, it's page 113, my lord, the insurance policy.
Okay.
On the right hand side, second column, liability column, your lordship.
Yes.
Compulsory PA cover premium 100 rupees.
Yes.
This PA cover includes registered owner driver. When owner driver meets with an accident, then he's from his own insurance company. Here the whole case is there was no other second vehicle involved. It is from the own insurance company.
Okay.
There is no second vehicle involved, because while driving the vehicle, allegedly he said that the cow came, and while trying to save the cow, it fell into a gorge. Then car got damaged and he died. So no second. They are claiming from their own insurance company, and from your own insurance, you can claim only if a registered owner driver is driving, and that also if you have got PA cover premium is there, then owner driver will get. And that PA cover is there for 100 rupees extra premium is paid for that. And then there is a legal liability to WC to driver to 50. Now here is that the clause in PA cover, it is up to 2 lakhs as per this policy.
Where is it written?
The person included insured. The liability clause 1, 2, 3, 4. If your lordship comes.
This copy also is not so legible, not clear. I can't make out.
Your lordship, that below, if your lordship is below that first, second, third PA liability clause under section 11(1) of the policy, death or bodily injury, such amount as is necessary to meet the requirement of the vehicle, of policy damage to third party property 7.5 lakhs, PA cover under section 3 for the owner driver is rupees 2 lakhs. Compulsory deductible over there, clause the column 1, 2, 3, number 3 in that liability clause. Cover under section 3 for the owner driver is rupees 2 lakhs.
Yes.
So here our only submission is that he, being the husband and family member, he has stepped into the shoe of the registered owner, and he will be covered under PA cover, entitled to maximum of 2 lakhs rupees. And then with interest, whatever it is permitted, that is all. That is other grounds on which it is, of course, challenging the tribunal without proper satisfaction with regard to their salary and everything, has given an inflated amount of 4,90,000 with interest of 9% from the date of the claim petition.
You are not on that.
That also we are challenging. We've taken that ground on that also because there was no proper satisfaction.
But are you pressing that?
Yeah, at the same time, if this comes, your lordship treats that he is not he is a third party. In that case, also whether the compensation which was given was proper or not, which has been awarded.
Then you have to state your argument on that point.
Yes. Yeah. The claim was again filed under section 166. So the negligence was also. Now, if you have to again make your own insurance company to claim, the negligence was also not proved. Mainly on this ground only, your lordship.
See, if you are pressing on the other grounds, as you have said.
No, not mine.
You have to.
It is mainly on this ground only we are pressing. I've gone through my. I've gone through my yes grounds.
So now the only ground taken
as a third party. Yes.
So only on that point of.
Yes, that is the main point.
PA.
Whether it will be third party or.
All other grounds are not. Yeah. Right.
I only reserve the right to submit one case law which is not available here. The National Insurance Company is at Balakrishna, the 2013 one. One SSC. I will provide that.
You file a short
written sir.
Giving all the facts of the case.
Okay.
And then cite those authorities.
My lordship. My lordship, paper book page number 113, my lord. This is the certificate of insurance policy, my lordship. I start with this one. My lordship, it is a package policy. It's readable, my lordship. This paper is readable.
Yes,
my lordship, this is a package policy. And liability column, my lordship. The insured paid the 100 rupees as well as the for liability to the driver 50 rupees, my lordship. Yes. As it is a package policy, my lordship, the person, those who are sitting in the vehicle, they are the occupant of the vehicle, my lordship. In this regard, I am to cite two citation, whatever they have already cited, mentioned in the paper book, my lordship. Page number 128, my lordship, paper book. Yeah. Page number 128, my lordship. Allow me to read, my lordship.
128 is
of the paper book, my lordship. Yes. It is also worthy to note that the High Court, after referring to the individual.
This is what 128 is what.
This is a circular, my lordship. If it is a package policy.
Page 128 of this paper book.
Yes, my lordship. Paper book.
This is a judgment.
Judgment only. Allow me to read, my lordship, this paper. If it is a package policy, if it is.
Para? You're reading
Para 20, my lordship. Paragraph 20, my lordship. It is also worthy to note that the High Court, after referring to the individual circulars issued by the various insurance companies.
Para 21. In view of the opposite factual position.
Same only, my lordship. Yes. Allow me to read, my lordship. In view of the opposite, it is clear that comprehensive package policy is of a two-wheeler, covers a pillion riders, and comprehensive package policy of private car covers the occupants and where the vehicle is covered under the comprehensive package policy. There is no need for motor accident claims tribunal to go into the question whether insurance company is liable to compensate for the death of.
Your reading is not. It's not telling me what is there.
Is there yes. Paper book, page number 128, my lordship.
Please read again from the beginning.
Which one you are reading?
It is mentioned here, it is 20, my lordship.
What are you reading?
11, 19, 9, 10, 11.
Page 128.
128, my lordship.
Yes.
Below, last paragraph, my lordship.
Yes, this last paragraph.
Yes, they have given.
128.
Yes, my lordship, it is 20 written here. It is supplied by them
No,
only.
no, please read again.
In view of the aforesaid, it is clear
No,
that
see, here it says in view of the opposite factual position, there is no scintilla of doubt
That
a
is para
comprehensive-
21.
She's reading para 21.
In view of the aforesaid factual position, there is no.
my lordship, I'm reading para 20, my lordship.
Para 20 starts with, it is also worthy to note.
Yeah,
You read first.
it is yes, only I have gone through already, my lordship. It is also worthy to note that the High Court, after referring to the individual circulars issued by the various insurance companies and
Yes.
eventually stated thus.
So you're reading para 20,
Yes, my
but
lordship.
you're saying 21. You keep saying 21, so
Sorry, my lordship.
okay.
In view of the aforesaid, it is clear that comprehensive package policy of a two-wheeler covers a pillion rider, and comprehensive package policy of a private car covers the occupants, and where the vehicle is covered under a comprehensive package policy. There is no need for motor accident claims tribunal to go into the questions whether the insurance company is liable to compensate for the death of or injury of a pillion riders or a two-wheeler or the occupants in a private car. My lordship, in the present case, it is a private car package policy, my lordship.
Yes.
And the driver is the occupant of the vehicle, my lordship. In fact, in view of the TAC's directives on those of the IRDA, such plea was not permissible and ought not to have been raised as, for instance, it was done in the present case. Then paragraph number 21, my lordship.
Yes.
In view of the aforesaid factual position, there is no scintilla of doubt that a comprehensive package policy would cover the liability of the insurer for payment of the compensation for a occupant in a car. So it is as it is a private car, my lordship, the driver is also a occupant in the car. On the basis of this, the lower court passed the judgment, my lordship. Only on the basis of this. And as they are saying, no, it is whether it is a third party or not, my lordship. My lordship, I want to place one citation in this regard, my lordship. My lordship, page number 5. Page number 5. Paragraph number 10, my lordship. Page number 5, paragraph number 10. In the present case, the deceased, although was a husband of the insured having a valid driving license and who was not a party to the agreement of the insurance, would undoubtedly fall within the meaning of a third party, my lordship. It's clearly mentioned in the paragraph.
Which one? Which case law? Which case law?
Which is cited by the lower court, my lordship.
Which one?
Subba. This is branch manager versus Mr. Subba. It has been held that learned tribunals, we may refer to the paragraph 30 of the improved judgment, my lordship. In this regard, one may go through the provision of section 146 of the MV Act, which speaks necessity for insurance against third party risks, my lordship. The object of this provision is to enable
You're reading that para 10.
Same paragraph, my lordship. Bottom of the page, my lordship. Bottom of the page. In this regard, one may go through the provision of section 146 of the MV Act, which speaks of necessity for insurance against third party risks. The object of
Just,
the
see this para at page 5.
page 5, para 10, my lordship.
Yes, sir.
Allow me to read again, my lordship. In the
Yes.
present case, the deceased, though
Yes.
was the husband of the insured, having a valid driving license, and who was not a party to the agreement of insurance, my lordship. There are the disease is not the party to the agreement of the insurance companies. There is insured and insurer. They are the two parties. They are the two parties for the agreement, my lordship. Would undoubtedly fall within the meaning of third party. There are first party is a insurer, my lordship. Second party is a insured. Others all are falls under the third party, my lordship. It has been held that learned claims tribunal, we may refer to the paragraph 32 of the input judgment, my lordship. In this regard, one may go through the provision of section 146 of the MV Act, which speaks of necessity for insurance against third party risks. As it is a comprehensive package policy, my lordship, those who are the occupant in the vehicle, they are also entitled to get the compensation, because it is a that premium is so high, my lordship. If it is a comprehensive package policy, the premium is very high. There's a two kinds of policies are there: act policy and comprehensive package policy. Nowadays, private vehicle, they are all insured with the package policy, my lordship, because to cover the risks of the other occupant of the vehicle. As least if it is a small vehicle, my lordship, 5 person can sit on the vehicle. So along with the driver, they are entitled to get the compensation if there is any accident took place, my lordship. So it is clearly mentioned by the section 146 of the MV Act, my lordship, which speaks of necessity for insurance against the third party. Here, my lordship, the lower court treated the disease as a third party only because, my lordship, he is the occupant of the vehicle, because he has paid the huge amount, my lordship. They say it's around 10,000. They have paid the insurance policy, premium as a almost 10,000, my lordship, as per the certificate insurance policy, my lordship. She insured has already paid the amount, my lordship, for the cover of the insured also, as well as the driver also, my lordship. Send my lordship, kindly page number 8, my lordship.
Hero.
Same citation, my lordship. Page number 8. Top of the page, my lordship, it is written here, subclause 2.
Yes.
As regards the impermissibility of the switching claims under section 163 to section 166 of the Act, urged by the Tupen Go Bhutia, learned counsel for the appellant, the condition on the face of it does appear to bear some substance, but not deeper consideration in the light of the object of the Act. Various decisions, more particularly Gautam Vadi and others, General Manager, Karnataka Road Transport Corporation, others, my lordship, then 3, my lordship, undeniable by the Act. The particular chapter 11 thereof was introduced as a benevolent piece of legislation. My lordship, this is a section 163. If it is case is not maintainable under section 166, my lordship, then it will maintainable under section 163.
That point has not been
as they have raised, my lordship, as she has already raised the questions.
Raised, but not pressed.
My lordship.
Now you only have to satisfy this court only with regard to that
third party.
The
third party, my lordship.
The contention,
yes, my
that the deceased driver
is a third party,
being the husband of the owner,
yes, my lordship,
has stepped into the shoes of the registered owner when the said accident occurred. So you have to distinguish that, and also you have to satisfy this court when you say that the occupant of the vehicle is considered a third party.
Yes, all these are the only question.
Whether driver is also occupant or driver is a separate entity or consideration.
So in this regard, I want to
that you have to.
My lordship want to place one more citation, my lordship.
Which is the citation? That's Kim High Court.
This another.
What is the citation, please?
You give them a copy.
Which is it? Reported in?
Yes, reported.
Reported in EIR. What's the party's name?
New Reassurance, Hemlata Larson.
You have another copy?
No, I don't. My lordship, in the citation, page number 5, my lordship. Citation number 2, page number 5, my lordship.
Just one. Page number?
Page number 5, my lordship. I've already pointed out, my lordship. Page number 5.
Para?
Para 6, my lordship. The rival contention of learned counsel for the parties have been heard in details, in extent show, and the records of the learned amnesty, including the impugned judgment, carefully perused. The question falls for consideration before the court is whether the amnesty was correct in having granted compensation to the respondent number 1. Then paragraph number 7, my lordship, while addressing the question, it may even relevantly be recapitulated that the court in Mrs. Master Sudas Subba had opined that where the deceased, the husband of the insured, was not a party to the agreement of insurance, had a valid driving license, and was driving the insured vehicle, he would undoubtedly fall within the meaning and ambit of third party, my lordship. In this citation also, my lordship, they are clearly saying that, my lordship, driver is a third party, my lordship. If driver is not the person of the agreement of insurance, first party is the insurer, second party is the insured, and the driver is the third party, my lordship. In this regard, one may go through the provision section 146. So 146 of the MV Act, my lordship.
Oh, this, I think you have already read this.
Yes, my lordship. It is reiterated in the same. It is another citation also, my lordship. But it is clearly mentioned that if the driver is the third party, it can be driver can be treated as a third party, my lordship. And my lordship, kindly see the page number 9, my lordship. Page number 9. Page number 9, my lordship.
Same judgment.
Same judgment, my lordship. Page number 9. But I have already marked, my lordship, with pen. One circular was issued by the IRDA, my lordship. IRDA, my lordship, dated
yes.
Allow me to read, my lordship. It's the subject to the limits of liabilities as laid down by the schedule hereto. The company will indemnify the insured in the event of an accident caused by or arising out of the use of the insured vehicle against all sums which the insured shall become legally liable to pay in respect of death or bodily injury to any person, including occupants carried in the vehicle, my lordship. It is also reiterated, my lordship, occupants carried in the vehicle. So driver is also a occupant in the vehicle, my lordship. So he may be treated as a third party, he may be treated as a occupant in the vehicle, my lordship, as because it is a private vehicle, my lordship. But except so far as it is necessary to meet the requirements of the Motor Vehicle Act, the company shall not be liable where such death or injuries arise out of the and in the course of employment of such person by the insured. It is further brought to the attention of the insurer that the above provision are in the with following circulars earlier issued by the TSC. TSC means, my lordship, Tariff Advisory Committee.
Okay.
Circular number 1878 and such, my lordship. The above circular make it clear that the insured liability in respect of occupants carried in the private car and pillion rider carried on a two-wheeler is covered under the standard motor package policy. As my policy is a package policy, my lordship, so it is very much clear. They are the occupant of the vehicle. They can be treated as a third party. So I am entitled to get the compensation, my lordship, and which is 100%. The lower court, below the court, or MSCT tribunal has correctly passed the judgment, my lordship. This is my submission.
My lord, just 2 points I would just like to point out, my lord. It is the same decision which my learned friend is relying upon. If your lordship will kindly turn to page 129. This is that Sunita Devi and others versus Company Limited. And this is a case law relied upon by her. Uttarakhand High Court, page 129. Page 129, paragraph 13. Page 129, paragraph 13.
Yes.
As far as the limited liability is concerned, the original policy has not been filed by the insurance company to show that the liability of the insurance company is limited only to rupees 2 lakhs, though it is reflected that the limited liability for third-party property is 7.5 lakhs and PA cover under section 3 for owner-driver is 2 lakhs. But as the entire policy has not been produced in that particular case, my lord, it will not be proper on the part of this court to hold that the liability of the insurance company towards the private vehicle owner would only be up to 2 lakhs. Moreover, the driver is not a third party. He is covered by the policy. He is not treated as a third party.
Yes.
Now, again, your lord, if your lordship will kindly turn to this National Insurance Company versus Balakrishnan and another. Here also, if your lordship will just come to page 136. This is also case law which my learned friend also relied upon before the tribunal. We have enclosed with the in this appeal paper book. Page 136 at the bottom, paragraph 14. In New India Assurance Company Limited versus Sadanand Mukhi and others, the son of the owner of the insured while driving the motor vehicle met with an accident and died. The accident allegedly took place as a stray dog came in front of the vehicle. The stand of the insurance company was that in view of the relationship between the deceased and the owner of the vehicle being father and son, the deceased was not a third party. This bench also relied on the decisions in same thing is held in Tilok Singh, in Juma Saha, Meena, on all these cases where it is the same thing is held and came to hold that the insurance company was not liable to indemnify the owner. This is a bit now where the confusion, my lord, what my learned friend, I totally agree with what submission has been advanced because these are all matter of policy decision and matter of record. Now these circulars that occupants covered or not, that was the issue before the IRDA also. When we say the occupants, when you are claiming from your own vehicle, the difference is when you are, so far as if two vehicles are involved in an accident, and we are claiming compensation from the insurer of the other vehicle involved, then all of us are third party. So far as the insurer of the other vehicles are concerned, to them, all the occupants, everybody will be a third party, and as a third party we can claim. Here the whole thing is when you are claiming from your own insurer. When you are claiming from your own insurer, if it's a package policy, the whole thing what this is decided in this second case, the Balakrishnan case, in that whether when you say the occupant, whether that they will be treated as a third party and the compensation will be insurance company whether will be liable to pay compensation for the occupants, your own insurance company. So that was what was decided, and there is a distinction, Milan. occupants of a company, occupants of a car and a driver, there is a difference.
That's what I was
You
asking.
cannot say the driver is also an occupant. He is an occupant, but he is an occupant in the capacity of a driver. The law is settled. If a owner, if a family member, husband or a son or a family member is driving the vehicle, not a paid driver. If a family member is driving the vehicle of the registered owner, then he steps into the shoe of the registered owner and he will be covered under the owner driver PA cover. It is not denied that they have. Then why have you paid PA cover? You are not required to pay PA cover. You don't need to pay PA cover then. And you will also become an occupant. If you are claiming then this, to cover the other occupants, you are paying this extra 50. 5 persons can sit in a vehicle. The other 4 persons, that do not include that 50 rupees extra you are giving for other. That is not for the driver. That is for the other occupants of the vehicle. Whether they can be, insurance company will be liable to indemnify the insurer for the other occupants, treating them as third party. So that is the confusion that is trying. The tribunal below also misconceived that case law, my lord.
Yes.
That is my submission. This is only one small point. This is a law point which really needs to be. And then the case law which my learned friend has submitted, the Sikkim High Court, I have said basing on that is a 2014 case law. And these case laws are of 2020 or 22, where also it has been held that driver will step into the shoe of the registered owner. I will file a written submission with all the relevant case laws, my lord.
Both parties can do that.
I have the second citation is 2024 case law, my lordship. Citation number 2. It's a very recent.
Give us a photocopy of this. I will read this judgment and then I can
MSC case of 14 of 2024. It is a very recent case, my lordship. It's the last month of November, I think it was.
Can I just go through this?
It was published.
Here only I will address. Let me just go through it.
What's the party's name? Have you given a copy?
Yes, my lordship.
Just write down New India Insurance Company, Hemlata, Laksam and another. Which portion you are relying on?
This is the one you have relied.
Yes, my lordship.
Which one you are? Which portion you are relying on?
All those paragraphs that you have cited.
Yes, my lordship. I have already given marking. Also, I have already given, my lordship.
Okay. So you file your written argument then.
Written argument, my lordship.
Miss Senior Counsel.
Okay, I'll go to this is from Sikkim High Court.
Along with Sunzo, appearing for the appellant. Also heard Miss Direct Counsel appearing for the respondent. On conclusion of the hearing, parties have, learned counsels have prayed for filing of written argument. We allowed. This is matter of 2 weeks.
Obliged, Your Worship.
Second call, item number 6.
Please, Lordship. Lordship, this matter can be passed over for the day, Lordship. Lordship, this matter is being led by the learned Advocate General, Lordship, and he's still on legs before the court number 2, Lordship.
Matter has been heard.
No, madam.
What is this case about?
It's a case involving police encounter.
Oh, police encounter.
Yes. So our prayers.
Is it police encounter not custodial debt?
No.
No, my lord. This regards that HNC, the Chesterfield matter, Lordship.
Okay.
Our prayers to hand over the investigation to the CBI. That is our.
With regard to that debt.
Yes.
But there's only judicial inquiry in there.
We are aware of that. There's a magisterial inquiry also. Commission of inquiry also has been appointed.
Exactly.
Yes.
Have you brought all those on record here?
Yes.
On preliminary report. We'll have it after 2 weeks then. This is matter after 2 weeks.
Obliged.
Much obliged.